non-U.S. company outside the United States, and there are Americans who work for this company. Are they in any hot water if the company does business with a sanctioned country or sanctioned entity?
Well, this is Don. I think I actually spoke to that, where you have U.S. employee of a foreign company, and yes, they are. And I think it's worth noting that in that case, it's not the company necessarily that's going to be on the hook. It's actually the U.S. employee. And I don't think this is going to be targeted necessarily at the guy on the loading dock. So the lower you are in the organization, you're luckily safe from secondary sanctions. But the higher up you go, it certainly becomes a problem because you're more involved in the decision making of that company and you're more involved in the actual transaction in the sanctioned country. In addition, the higher up you go, the harder it is to isolate an executive from those transactions and from the decision-making process. So again, if you can be relegated to a division that has no nexus or no connection with the sanctioned country, good. If you're the CEO of the company or the chairman of the board, who obviously couldn't necessarily be isolated from the business of his company, then you could be in hot water.
Our final secret word is violations, violations. And one last question, does OFAC prioritize enforcement of some sanction programs over others? And I believe, Christopher Riedling, are you still with us?
Yeah. So I'm happy to answer that. OFAC does not prioritize, for at least when it enforces sanctions. So I should point out there's a distinction between sanctions and sort of violations of prohibitions. The sanctions, at least from OFAC's perspective, I understand the private bar doesn't use this language, but in OFAC, when they say sanctions, they mean designations. They don't mean a U.S. person violating a law or an EU person causing a U.S. person to violate. They only mean sort of list-based actions or embargoes. But with respect to does OFAC enforcement prioritize a specific program, for instance, Iran or Cuba, the answer is no. OFAC's much more interested in the egregiousness of the conduct than they are in the program. So if you notice, Zoltek is a case that came out recently, involved Belarus, which is a program that I don't think a lot of people even know exists outside of the sanction space. But they were there to enforce that specifically because they wanted to make the point that if a U.S. executive is facilitating the transactions, they can be liable. So yeah, you should really be looking at how severe is the conduct rather than think, oh, my violation is a Zimbabwe violation, so I don't have to worry about it because it's not Iran. The better way to think about it is, who at my company knew about this and maybe willfully affected the transaction, because OFAC is going to be much more interested in the willfulness than the program itself.